they won't be the one to try them. They will still have to go to the judges. So, and it is better to have a sound peer review before you go into court system. And this will go a long way to assist the system. NJC will never condone a corrupt judge. They will never cover up a judge that has been accused of taking bribe if there is concrete evidence.
On the surface, it looks like all is well. I mean, it's on the surface, a lot of people will agree with this in principle. But then the country has a history. I mean, we're coming from somewhere. This is the first time we're seeing so many judges in the limelight, sadly. And the talk about corruption in the judiciary has been quite rife. Do you think that the NJC, in some ways, has also brought this to the judiciary by not being proactive in terms of taking actions against judges?
To the best of my knowledge, NJC may be slow because of their training and their nature being judges. You don't expect them to be acting like policemen or DSS men. Or these are judges. They're used to procedure. I do not think they brought anything to the judiciary or to the legal profession. I think we need to be patient with them, and then we should follow it up. Whenever there's any complaint, lay it properly before them, follow their rules. For example, I'm aware of some petitions written to the NJC by some of the agencies. And the rule under the NJC is that you must accompany your complaint with an affidavit. This petition was never accompanied with an affidavit, and it was turned back. Then look, follow the procedure. If you follow the procedure, you get there. I think we need to be a bit more familiar with how NJC functions, and then there should be what I would call a proper synergy among them, that is DSS, police force, EFCC, and NJC.
Do you think the way it also works can be something that is hampering it, in the sense that it will not function unless there is a complaint? In this instance, the EFCC, there was no complaint to the EFCC, there was no complaint to the NJC either. The EFCC went on an investigative mission and found what they found. In this kind of instance, do you think that, I mean, considering the fact that the NJC doesn't have investigative powers, do you think that it really can be as proactive as it ought to be, considering the circumstances that we found ourselves?
That is why I say, if the complaint against a judge also borders on misconduct, which is under the authority of NJC, the authority, be it EFCC or DSS, should draw the attention of the NJC to it. And besides, EFCC will not act except there's a petition as well. There must be a petition. They will hardly act without a petition. They will normally react to a petition. So I do not know how Nganjiwa's matter came about, but without a petition, it is most unlikely that EFCC will act. Well, if they pick it up from the system, or they pick up anything, at least they will be acting on something. And if whatever they discover concerning a judge, I go back to this judgment, all it's saying is, the first point is NJC. NJC. After NJC, then other things can follow. It's all about due process.
Oh, well, we're reading here. I don't know. We don't know how far this is true, but we'll need to confirm it, about how the EFCC had sought clearance from the NJC to proceed with the matter of the prosecution of the judges, and maybe they felt that that clearance that was given in respect of the 5 judges eventually, because we know that the DSS could not prosecute the judges, they had to transfer the case to the EFCC, and it was seen that there was some communication between the EFCC and the NJC. Perhaps they thought that that was general clearance for them to continue with all the other judges that were found.
This judgment is not talking about clearance, whether formal or informal. What it's saying is that that judge must be made to go through a kind of investigation by the NJC. And without listening to the judge, without seeking his input, without hearing from him, a mere letter will not be sufficient as far as this judgment is concerned, because he deserves to be reviewed by his peers. That is what this judgment is all about. And like I said, it is not only in judiciary that you have something similar. We have something similar in the police, in the Armed Forces, and in the Armed Forces Act, where an officer or a member of the Armed Forces has been court-martialed and he has served his sentence, he may still be prosecuted in the normal civil court. And that the civil court will have to bear in mind whatever sentence or punishment he has gone through from the Armed Forces. So it is not a strange thing. It is there.
For some Nigerians, they have a problem with the fact that it is the pairs who have to first of all review their fellow judge. They believe that that system in itself is faulty.
Well, they may have to go for a review of the Constitution. I think we are talking of what the law is and not what the law ought to be. The law as it is today, as it is interpreted by the judges, is that you must follow this step. If they are now calling for a review, let them go to National Assembly. That will not fault this judgment. That will be affirming this judgment, but asking for a review that they don't like it. And that will be subject to debate.
No, but you don't see any problem with that particular process?
I do not see it, speaking for myself, because if you are reviewed by your peer, for example, you are talking of a judge. If he goes before his peers and they say, oh, you have done the wrong thing,